So we got it, and we had a meeting since then. We had a meeting recently.
One moment.
I don't recall us not
confirming
minutes up to this point. So I'm wondering. I would think that the last meeting will be the minutes outstanding. All right, so what I'll do is I'll allow you to check that for me and we can deal with it at the close.
Yes, I'm almost finished.
At the close of this session here. We want to hold up the time. And we can deal with the confirmation and matters arising. So let me invite the MSET team to take up from section 4, and hopefully we will go straight through to 8, which is what we have in front of us so far. So, CTD Murray, are you leading?
Yes, Chair. Thank you. Good afternoon, Chairman, members of the committee. My apologies, 1 second. Right, there you go. Afternoon, Chairman, members of the committee, colleagues. Picking up from section 4, and I will share my screen. Right, just to confirm that my screen is being seen.
Yes.
And I'm being heard. Thank you. All right, so section 4.1, we had basically three sets of comments from the Financial Services Commission, University of the West Indies, and the Ministry of Education. The Financial Services Commission is recommending or recommended that the offense at section 4.1 be amended to include or to add the words rather, or causes to be accessed. So you'll notice that the provision says that a person commits an offense if that person accesses, and they're recommending that the words or causes to be accessed be added. With respect to the University of the West Indies, they have sought clarity on whether or not, in addition to the reference to access, the word possession, whether or not the word possession should also be included in the section. And then with respect to the Ministry of Education, well, the then Ministry of Education, Youth and Information, now the Ministry of Education and Youth, they requested that the section be adjusted to provide for stricter punishment when the offense relates to a child. They note that section 4 in its current form makes it possible for someone to be punished for possessing an indecent picture of a child vis-a-vis child pornography, which is an offense punishable by imprisonment for a term that exceeds 1 year. So their suggestion or recommendation is that section 4 can be adjusted to include a provision that offenses relating to children will attract harsher penalties, with the penalties clearly outlined. Alternatively, they have recommended that there could be a schedule of offenses that will attract harsher penalty, which would include sections 4 and 5 of the Child Pornography Act, which carries a penalty of up to 20 years. So members, as I indicated, section 4.1 of the section 4 rather of the Act seeks to criminalize actions that utilize, where an individual utilizes the computer to, or accesses a computer with the intention to commit or facilitate the commission of some other offense. So we'll note here that it says a person commits an offense if that person accesses any program or data held in a computer with the intent to commit any offense punishable by imprisonment for a term that exceeds 1 year, or to facilitate the commission of an offense. Section 2, subsection 2 of the Act defines access as occurring when a person causes a computer to perform any function, and more specifically, when that person when that function copies or moves the program or data to any storage medium other than where it currently is. And we note that additionally, section 4.3b provides that for the purposes of the section, it is immaterial whether the offense referred to in subsection 4.1 is committed at the same time that the access is secured or at some later time. So in considering the recommendations from the various stakeholders, we note with respect to the Financial Services Commission's recommendation that section 12 of the Act, and I'll scroll up a little bit because provisions of that section are outlined just above here. Section 12 of the Act provides that a person who intentionally incites, attempts, aids, or abets the commission of any offense, or conspires with any other person to commit the substantive offense, commits an offense, and is liable to the same penalty as applies to the substantive offense. So we believe that by virtue of section 12, the Act already treats with the matter of inciting and conspiring with another person to commit any offense under the Act. And therefore, we see no need to further amend section 4.1 to add the words or causes to be accessed. Because if someone causes through a second or a third party access to, then that person would potentially be falling in the realm of conspiring with another person to commit the substantive offense. With respect to
question on that section, Mr. Chairman, may I go ahead? Okay, thank you. I just want to ask a question. Section 12 states intentionally incites. So no, go back down to 4.1, please. Section 12 says intentionally. And here in the comments section, you have stated that section 12 deals with inciting and conspiring. Is it that we are not going to be looking to penalize carelessness? Because I got the impression from the UA presentation, from the presentation from FSC, that the cause to be accessed was not about intention, but about not being careful enough, and as such, access is gained. I could be wrong, but I think that's the distinction. And if that's the case, if that was their intention, 12 would not cover it because 12 requires intention.
We read the recommendation from the FSC to be suggesting that a person can either himself or herself access a computer to commit an offense, or can facilitate, replacing causes, facilitate access.
But that's not what they said.
They said causes.
Right, they didn't say facilitate, they didn't say incite, they never said conspire, they never said intentional. So I think before we just blanketly say we're not accepting this, we have to discuss the issue of whether or not that recommendation was, or even if we think carelessness should be penalized, and then we can look at whether or not cause to be accessed is something that we should add. So you're interpreting it that facilitate is what they meant, but
we would have to clarify that with their member.
Sorry?
I said we would have to clarify what their intention was, because that's how we've interpreted it.
Right, we should, one, clarify, but also within, among ourselves here, we should have that conversation as to whether or not we think carelessness is something that should be considered for the cause to be accessed, because if here we agree that that is something that should be considered, you know, it being done without intent, we don't even need to go back to them. It's what we agree here as well. That should be taken into consideration. So I don't know if other members of the committee have any thoughts on it, but we can't just assume that it's only intention, because we're dealing with cybercrimes. So
here, my thinking on it is, in this situation, whether someone with intention purposely access the computer and then proceed to carry out the action. I would be a little concerned about applying carelessness on it when it could have been someone carrying out the function and accidentally access information. The question is if that person now continues to pursue a particular action, which would have been deliberate, that could be understood. But I wouldn't insert in it the question of carelessness, because that would widen the scope a little bit. I would stick with the question of, where it was intent and they deliberately pursue the action.
Well, let me ask a question, Senator Gill. What then is to stop someone who purposely did it from saying it was accidental?
And then again, that would have to be investigated. So you accidentally access, but when you continue to pursue the action.
No, it's not continually access. It is you accidentally caused someone else to be able to access. So that person has gotten off. Because yes, you can deal with the other person because they may commit an offense, but you can say you accidentally caused them to gain access.
And so the punishment can't be the same.
No, it shouldn't be. So that was going to be my second point. But I'm saying we shouldn't just assume that we should not add cause to be accessed.
Well, the important thing in this, Natalie, is for us to get somewhat that body who was making the presentation,
exactly.
What was their intent when
exactly,
they represented.
Because this is Financial Services Commission that made this.
Yeah.
So when you look at the work that they do, that whole issue of carelessness, because it becomes a defense easily, very easily. Oh, it's mistake I make, and then the man, and so Sam was able to access and then take 14 million because I accidentally. So I do think we need to go back to them.
But again, you'd agree with me that the Act would also prescribe, any intention on the Act would also prescribe the opportunity for protection against accidental occurrences.
Yes.
Not to just rush to judgment.
Yes, absolutely. And so that is why we have to say an entity like Financial Services Commission, I would not take an assumption on what they meant. I would specifically ask. Because their work is very specific and it is often the place, the world of finance is often the place where a lot of cybercrimes occur. So I would not assume they meant intention. They may, but so if the committee can please just ask about that for us. Sorry,
maybe I should add, and we will, my apologies I haven't turned on my, member, we hear the concern, but just to point out that the manner in which they proposed the amendment didn't suggest that they wanted to add any other mental element, because they were recommending that the words or causes to be accessed, which would follow, I'll just do a little copying and pasting here, which would actually be inserted accesses, and this is where it would actually be inserted, so that it would read this way. Or causes, accesses or causes to access any program or data held in a computer with the intent, based on how it is that they recommended the amendment. So we assumed that they still intended, or they didn't intend to rather, amend the mental element or change the mental element to anything other than what is there now, which is intent. But
the operative here would be with the intent.
Right. And
right.
But
so
but
I
Ms.
hear
Maureen,
members saying that we are to find out from them if they meant to include intent or recklessly. And so we will inquire.
Please, thank you. I would really love if we could inquire. Thanks. In the clarification from them, can we just include what I have said? So, you know, they get a fulsome understanding of what we're trying to clarify. Yeah. Thank you.
All right, so with that interpretation, we didn't see the need for it because, as we indicated, the mental element would still remain the same and it would be captured under Section 12. But we will, based on the conversation that just occurred, inquire of the FSC what exactly its intention was. With respect to UE and their recommendation, or its recommendation rather, that the word possess also be included, so that it would read, if that person accesses or possesses. We note that sections 2, 2, and 4 of the Act, when read together, address, or we believe rather, that sections 2, 2, and section 4 of the Act, when read together, would address their concern, because section 2, 2 speaks to the matter of accessing, and accessing has been defined or is defined in the legislation to mean copying or moving. And we think that because it includes the copying or moving of the computer program or data to any storage medium or to a different location, then the offense would have been treated with in terms of possession, because if you're going to copy and move, then clearly you would then have possession of. And so we think the words copies or moves would treat with the issue of the person possessing the computer program or the computer data. So the act of copying or moving is considered possessing in the context of the legislation. And so with that interpretation, we wouldn't support, or we don't support the insertion of the additional word possession, because we think that it is already captured in the definition of access in section 2 of the legislation. With respect to the Ministry of Education, that has, and I'll just remind the committee what they wanted us to, well, the committee wanted, what the MOE wanted the committee to consider is whether or not there should be a harsher penalty or harsher penalties for the accused when a child or children are victims of the offense. And we note here that while we understand and appreciate that children are a particularly vulnerable group, as are elderly persons and persons with disability, we're not seeing a need for a specific carve out for harsher penalties for children. We take the time here to point out to the committee that when the bill, well, when the act, the then Cybercrimes Act of 2010 was reviewed, there were significant changes made to the legislation to increase all the penalties, so as to reflect the seriousness with which cybercrimes are being treated. And it is our view that the penalties are harsh and send that signal, and would be applicable to any person, irrespective of who the victim is. So whether that victim is a child, whether that victim is an elderly person or person with disability, the penalties as now stated are sufficiently harsh. One of the other things want to point the committee to is the fact that Section 4 of the Act is a general section that does not preclude prosecution under any other piece of legislation. So consequently, the accused could be charged under the Cybercrimes Act, as well as the legislation treating with that substantive offense. Bearing in mind, members, that what the offense created is one of intending or accessing rather the computer with an intention to commit a further offense or another offense. And so that person could be charged under that other piece of legislation in respect of that substantive offense. So consequently, the accused could be charged both under the Cybercrimes Act as well as that legislation. In this regard, and in regard to the Ministry of Education specific point, that individual would potentially be charged under not only the Cybercrimes Act, but the Child Pornography Prevention Act. And we note that the custodial sentences there range in the main from 8 to 20 years. So with that, members, we did not see a need for carving out and or adding a schedule with respect to harsher fines for children specifically.
Sorry, Ms. Morimi again. I completely disagree. 100% disagree. The government has stated clearly that we must protect our children because of how vulnerable they are naturally by being children. And furthermore, because of the problems we're having in Jamaica with children and the abuse of our children. How does it hurt to make stronger penalties for children? And this is a ministry that has responsibility for children. And at the time, they were also the Ministry of Youth. How can we not accept this recommendation? How does it hurt? It does more harm to not protect our children. I'm of a firm belief as a child advocate myself that it is better to go overboard in protecting our children than leaving them unprotected in any way. How does it hurt to accept this recommendation?
Chairman, I think what my Senate colleague is suggesting is that as we continue to progress in reviewing our legislations, we must amplify the point where we need to protect our children. Now,
absolutely,
it is aligned in other legislation, but it would not stop us from sending a very, very clear signal in terms of ascribing it in this particular legislation to strengthen the point. We did the same thing, when we went through the sexual harassment legislation. In that, the Sexual Offences Act would have spoken to some of these situations, but we thought it fit in our deliberations to ascribe with intent safeguards in the sexual offenses legislation to strengthen the position. And I believe every opportunity must be utilized in promoting our legislations to create these types of safeguard. It doesn't harm. There's no harm to it in my mind. So I would want to suggest that.
And it's the government's policy to protect children. It's because we have a specific problem, not just because they're children.
Sorry, apologies. Chairman, we'll be guided by the comments of the committee. The recommendations before the committee are the technical considerations of the team at the MSET. And so we'll be guided by the committee. As it is now, the offense for accessing a computer with the intention to commit another offense is $4 million and 4 years on a first offense, $5 million and 5 years where damage is caused, and on a subsequent offense, $5 million and 5 years, and that's in the parish court, bearing in mind the ceiling for which the parish court has jurisdiction. On conviction, on indictment before a circuit court, the offender can be, well, the court is at large there. There is a fine generally, or imprisonment for a term not exceeding 7 years, where damage is caused, 10 years, and where there is a second or subsequent offense, a term of 15 years. As I indicated, the person would be charged for accessing a computer with an intention to commit an offense. not the offense itself. And so, as I indicated, the offense itself, in respect of the child, that child or children, which the Ministry of Education had a particular issue with, pornography, etc., would, as I indicated, be treated within in the substantive legislation treating with pornography. And in that particular legislation, we note that the term of imprisonment goes up to 20 years in some instances and for some offenses under that piece of legislation. And so we would suggest that maybe what needs to be reviewed, if anything is to be reviewed, is the offense, the substantive offense, to ensure that those offenses or the custodial sentences and fines within those legislation are sufficiently punitive, because in this case, under the Cybercrimes Act, they're not charged with pornography or child pornography. They are charged for the offense of accessing with intent to commit another offense. And so if there are, how we understand it is that the law enforcement would lay a charge under the Cybercrimes Act and then also lay a charge under the substantive legislation, which that is the offense for which a person, so whether it's larceny or pornography or whatever else that person did, utilizing the computer, then they would also be charged and would then potentially be looking at a fine, or at fines maybe larger than, or terms of imprisonment larger than that contained in the legislation. But we'll be guided by the committee.
Ms. Murray, what does it mean to be guided by the committee? Because I just want the records to reflect clearly that in the same way, MSET does not support the recommendation of the MO, the Ministry of Education, for harsher penalties for children. Senator Natalie Campbell-Rodriguez does not support MSET's recommendation that there should not be harsher penalties. So what does the final sentence that you gave on the matter, what does it mean in real terms?
Meaning, remember that if it is that the committee is recommending that we take this matter, if it is recommending that harsher penalties be introduced, then that would be what would be tabled in the committee's report and would be held into Parliament for its consideration. That's what that means.
So, Member Campbell, as you know, we are responsible for policy. So the bottom line is that if that is what we are, as a committee is saying, then that is what the technical team will follow through on. So I don't hear any dissenting voices. So obviously, it's your position is supported.
Thank you, Minister.
Excuse me, Chair. This is Marlene Aldred.
Good afternoon,
Afternoon, Chair. Afternoon, members and colleagues. So my understanding is that the committee has agreed to accept the recommendation. However, it was a very vague recommendation. It just said harsher penalties. The committee will now need to go further to say what these harsher penalties are. And just to remind the committee, as it relates to the parish court, the penalties are already almost at what we call our ceiling. And so you'd have to bear that in mind when you're indicating what these harsher penalties would be. So that decision is still outstanding on the committee. Thank you,
Can we
Chair.
get some recommendations? For example, I'm not an attorney, so I would prefer to get some recommendations and from there to take it.
Sorry, say again, member, I missed that.
I'm just saying, rather than, for example, I'm the one who has flagged this issue, but at the same time, I can't give a recommendation off the bat as to what those penalties should be. I'm not a legal person. So I'm just asking if the legal team or the team could just give us some suggestions as to what would be viable options. And then from there, we can discuss around that. Is that an option for us? Versus committee members telling the penalty.
So what I'm hearing from CTD, Murray, and the SG is that the fines for the parish court are already almost at, if not at the ceiling. So is there is there something between what it is now and the ceiling? SG,
Go to the ceiling.
retrieve that.
Yes, Chair. So as from what I recall, it was 4 million and 4 years. We do have our quote unquote ceiling as 5 million and 5 years at the parish court.
So what then is the option of an increase?
Okay, so Chair, to be honest, this is not a legal issue. It's usually determination of penalties is not usually a legal issue. It is a policy issue. However, the lawyers can provide guidance just to point out, for instance, inconsistencies. But this sort of recommendation really should have been fleshed out a lot more by the Ministry of Education, Youth and Information. They really should have as to what they meant by harsher penalties. On the when you're determining what
So you're breaking up SG, you were in and out a while ago. Can you just repeat that?
Ministry of Education, Youth and Information. They really, this is something that needs to be guided by that ministry, because they really would then have to look at the type of offense, look at the existing penalties, and look and see what they want to achieve, as well as look across to ensure that there will be no resulting, let me use the word, inconsistencies with other similar types of offenses in other acts.
So I take it that you're saying that we should refer it back to the Ministry of Education with the committee's position.
I would suggest that, because I don't know if any of the technocrats in this meeting can really provide that kind of guidance.
All right, point taken. We will proceed on that and raise this at the next meeting and ask them for a response before the next meeting. Or better still, we may invite them to present. All right, CTD, continue.
Thank you, Chairman. So we then go to section 4.3. The private sector organization of Jamaica was of the view that section 4.3, the language was vague. We're not sure what they mean by, why they have interpreted the language of the section to be vague. So section 4.3a states that for the purposes of this section, it is immaterial whether the access referred to in subsection 1, that is the access to the computer and or data, is with or without authorization. So, and we've gone through this part already, section 4.1. So section 4.3a in our mind means that where a person accesses any data or program for the purpose of committing or facilitating the commission of an offense, punishable by imprisonment for a term exceeding 1 year, it is immaterial whether he or she was or was not authorized to access the computer, as the access would have been with a view to committing a criminal offense. So the fact that you are authorized to access or not authorized to access is essentially immaterial, because your purpose or intent for accessing the computer was with a view to committing a criminal act. And on the second point, that is with respect to ethical and wiretapping, we would have discussed that, the committee would have discussed that at length at its previous meeting, and we are to revert to the committee on that matter. Chairman, should I take it that if there is no intervention from the members?
Absolutely.
Okay.
Silence is consent.
Okay, thank you, Chairman. So we then
That
move.
could also mean considering, Chair, but anyhow, go on.
All right, so we give you.
All right.
So we give you a pause of 10 seconds.
Right. I'll pause a little before I move on, and it'll give me an
Okay.
opportunity to catch my own breath, I suppose.
I didn't realize that Senator Gale is not as sharp as I am.
All right, so we go to section 5.1, and post the committee meeting earlier this month, we realized that when JBA actually made their oral presentation to the committee on the 16th of June, they actually withdrew all their recommendations regarding recklessness. So we reverted to the minutes of that particular meeting, and when we read the text of the minutes, the provisions as well, the minutes itself, we know that they indicated that they were withdrawing their recommendation regarding recklessness on the basis that they had heard the presentation of the Office of Director of Public Prosecution, and they noted that that office did not raise an issue with the criminal mental element of intent. And since the act was operational for several years, they would not want to defer on that point. So while it is that, and so with respect to all the recommendations, or their recommendation rather, for the introduction of recklessness at various points in the act, we just want to just generally put that into context, or to remind the committee rather of what the Jamaica Bankers Association actually did in withdrawing their recommendation. Notwithstanding, the committee is aware since the last meeting and the last conversation that we would have had on the introduction of recklessness in the context of one of the offenses here. What was previously their initial recommendation was that recklessness be considered in the context of unauthorized modification of a computer program or data. We note from our research that many multilateral cybercrime instruments require that the crime of unauthorized modification, called unauthorized modification in our legislation, but referred to in other pieces of legislation in other jurisdictions as illegal data interference, is committed intentionally or fraudulently. We note that the League of Arab States model law does not mention intent in its data interference provision. And we also note that in the Commonwealth model law on computer and computer-related crime, that it requires criminalization of modification or interference acts that are, criminalization of modification and interference acts that are committed intentionally or recklessly. The United Nations Office of Drug and Crime, in commenting on the Commonwealth model law approach, notes, however, that same essentially creates a particularly broad basis of criminalization in light of the fact that it is often easier to interfere unintentionally with computer data or the operational computer systems than for objects or property in the physical world. Of the 81 countries reviewed in its study, the UNODC noted that only 6 criminalized reckless or negligent data interference or modification, and that the majority of which hailed from South America, Western Europe, and Africa. On our further research, however, we realized that there were other jurisdictions that actually introduced the mental element of recklessness as well as intentionality in the provisions relating to modification, and those jurisdictions include Australia, Barbados, Dominica, New Zealand, St. Vincent and the Grenadines, and the UK. We remain, notwithstanding that we identified a handful of countries that have added or include in their consideration the mental element of recklessness, we remain of the view that intentionality, recklessness would essentially subject persons to a disproportionate criminal sanction in light of the fact that it is easier to negligently or recklessly, due to ignorance, modify data, computer programs or data for the operations of a computer system just by mere ignorance. We also, and this is something that we would have mentioned to the committee at its last sitting, we note that the approaches in framing offenses can hinder the process for cooperation in the investigation and prosecution of cybercrime offenses due to the principle of dual criminality. And as a large number of cybercrimes have a transnational dimension and require international cooperation, cooperation is generally easier if the requesting state and the receiving states have similar legislation in place. We note that there is a move, and has always been a move, for internationally for governments to ensure legal protection is harmonized among nations and to prevent the appearance of what they term as computer crime havens. The context here being that if a cybercrime is an offense in one jurisdiction and not in another, then you could have a situation where that person could flee to the jurisdiction where the crime is not an offense, and therefore mutual legal assistance around the sharing of information for investigation purposes and or extradition could not occur, because that is not an offense in one country. We note that at present there are multilateral processes going on at the level of the UN, treating with the elaboration of a comprehensive international convention on countering the use of ICTs for criminal purposes, and that the move is really around harmonization rather than any harmonization of legislation in this particular area. We also note, because the JBA had requested that we introduce the word ought to know, that we didn't find any jurisdiction in which the requirement for ought to know was included in the provisions around modification or interference. And so essentially, Chairman, members, we are not supporting the introduction of, we do not support the JBA's initial recommendation that the offense be capable of being committed recklessly.
For further clarity on information, especially on my part, for those who have revealed, it was revealed that countries like Australia, Barbados, Dominica, New Zealand, St. Vincent and the Grenadines and the UK require the mental element of knowingly, intentionally, or recklessly inserted in their legislation. Just for reference and for my understanding, I would love to have seen how they would have inserted it and what it really means with their use of insertion. So if at a later stage...
Oh, I could actually share that with you now if you wish, and the
sure,
committee members. I do have, just give me a moment, please. All right, members, are you seeing my screen?
Yes, I'm seeing it.
Another matrix, sorry, which says New Zealand, etc.
Mm-hmm.
Right. So this particular offense is from the Cybercrimes Act of 1961 from New Zealand. And as I indicated, they use the language interfering with damaging or interfering, while it is that we use the term modification, but they're essentially one and the same. So if you note this is section 250 of their Cybercrime, of their Crimes Act, my apologies. And so at subsection 2, it says everyone is liable to imprisonment for a term not exceeding 7 years who intentionally or recklessly and without authorization, knowing that he or she is not authorized or being reckless as to whether or not she's authorized, damages, deletes, etc., etc., etc.
And recklessly in this case would not assume that it was intentionally done.
That's right, because for us, we read that as an option. Right. So, right, you could have intentionally done it or recklessly.
Or recklessly.
Right.
All right.
I'll just go back to sharing my original presentation. So that was with respect to the comments on section 5, subsection 1. On the matter of, with respect to section 5.2b, the private sector organization of Jamaica's concern essentially was that IT practitioners could be held liable for modification made to the content of a computer during the course of their duties or as they were performing contracts. So whether they are on staff or engaged as a third party. So they know that given the specialized nature of the IT, of IT and the central role that innovation plays, then it is important that IT practitioners be allowed to break stuff or to just do their job without fear of criminal sanction. So that was the PSOJ's comments with respect to the FSC. They requested that a third caveat be introduced, and that caveat would essentially provide that it is immaterial whether the alteration or modification is intended to yield or in fact yields a public benefit. Let me just, okay, so I wanted members to see the language of 5.2. So if you note here, members, section 5.2 states that for the purposes of subsection 1, the act in question need not be directed at any specifically identifiable program. And at B, it says it is immaterial whether the modification is or is intended to be permanent or temporary. And so the FSC's recommendation is that a third caveat be added to say that it is immaterial whether the alteration or modification is intended to yield or in fact yields a public benefit. We take the members back to section 2.6 of the Act, the Cybercrimes Act, that defines modification and provides in section 2.7 that modification is unauthorized if the person whose act causes the modification is not himself entitled to determine whether the modification should be made, and that person does not have consent for the modification from any person who is so entitled. So with respect to the PSOJ's concerns that IT practitioners could be criminalized for making modifications to systems as they are engaged in their work, or reading of the legislation suggests otherwise. For us, the section 2.6 of the legislation considers an act to be unauthorized if the person modifying the content of the computer is not entitled to control the modification or does not have consent. And so in our minds, any IT practitioner that is working on a system would have had the requisite authorization by virtue of his or her position or under contract, a third-party contract, to test the system, to work on the system, and therefore potentially modify things that are there. And so
no, go ahead, finish.
Right. So IT, for us, our conclusion is really that if IT practitioners conducting essentially components of their job with the appropriate authorization would not be liable for changes or damages incurred to the client's device or systems.
So I had some interest in this, and I support the view expressed by the PSOJ. And I think of a programmer within an organization who would have been conducting work in the scope of their level of responsibility, and may have had a breakthrough, whether an innovative breakthrough or otherwise, created modification. And so what you're now saying to us is that they would have been authorized to do so. And as a result of that, they would not find themselves negligible in this case because of their scope of responsibility.
That is our interpretation of it, member. And bearing in mind, I suppose, and I stand to be corrected by the Solicitor General on this, of course, within the context of who owns work, an employer versus an employee, and what is created and innovated, or where there's creation and innovation. That I suppose, unless it's articulated otherwise, becomes the employer's innovation. So we don't see an issue once it is that the person is operating within the framework of the scope of their employment.
But we don't get to the stage about who is going to own the innovation.
I know, I'm just saying that an innovation is an innovation. The concern that
I have is that in the breakthrough, that programmer may have caused a modification that may not have been intentional, but may have been damaging to the organization. And so we don't want a situation where the scope of permissiveness exposes the individual to the risk of being aligned with a criminal offense.
So again, remember, it would have to be with respect to what it is that what is the scope of their job function.
Their job function.
It really is a feature of that. We know that there are case law around whether or not, even as an employee, one would have acted outside of scope, because that is possible as well. And so for our reading of the regime in the legislation and other pieces of legislation is that really what we're saying is that when you are interacting with the systems, you are to be authorized to act. And if you are a third party coming in, then your contractual arrangements must be sufficiently wide to cover all that it needs to cover.
Are specific in nature.
Exactly, member. And then of course, if you are an employee, then you ought to know what your job function allows you to do or not to do. And to the extent that you believe that it does not, then clarification and consent should be sought.
Okay, all right. I hear you.
With respect to the FSC's recommendation that a third caveat be added to subsection 2, and that modification being one that refers to intended to, the alteration or modification is intended to yield or in fact yields a public benefit. The committee is asked to note that the legislation only allows authorized modification, because anything that is unauthorized falls within the context of what is deemed a criminal activity. So that a public interest test or assessment is not applied in determining whether a modification is justified. It really boils down to whether or not you were authorized to do what you have done, or if you received the relevant consent to modify. And so we don't think that a public interest test could be appropriately introduced here, because the scheme of the legislation is one that speaks to being authorized or unauthorized. Right, so the next section is section 6. The Financial Services Commission is of the view that section 6 treats with unauthorized interception of computer function or service. The Financial Services Commission thought the provision was overly broad. They note that network operators oftentimes deploy network monitoring solutions that intercept traffic on their own network. And this is done in order to understand threats on the networks. This can capture customer password keys and data if they're not encrypted. So the question for clarification, or the query that the FSC has, is the intention of this section to deem such activity illegal? We note that criminalization of illegal interception is intended to protect the integrity and confidentiality of the computer data. The primary concern behind prohibition of the interception of computer data in transmission is the breach of confidentiality in private communications. Of course, members are aware that privacy is one of the tenets of the Charter of Rights in our own Constitution. And so section 6, subsection 1 of the Act provides that a person commits an offense if that person knowingly secures unauthorized access to any computer for the purpose of obtaining directly or indirectly any computer service, or without authorization directly or indirectly intercepts or causes to be intercepted any function of a computer. We would have gone through, members, what the definition of unauthorized in the legislation means, and that is outlined at section 4 of the Act. And a person is considered unauthorized if he or she is not entitled to control the access, modification, use, or function of the kind in question, and or does not have consent from the person so authorized or entitled to give that permission or consent. We note too, it is not, with respect to interception, is not acting pursuant to the power or function given under the Interception of Communications Act. So with respect to FSC's query or observation is this, members, that the act of network operators viewing as part of their security operations, the existence, transmission, or interception of traffic on their own network carries no sanction or legislated requirements for reporting. The reason for this is that the legislation allows for authorized interception. what is not allowed for is unauthorized interception. However, this would not preclude the network operators from ensuring compliance with other pieces of legislation. For example, our Data Protection Act, which treats with the protection of personal data and sensitive personal data. So that if in the testing of their systems, data is intercepted, we would expect that in giving compliance to or complying with other pieces of legislation to include the Data Protection Act, then they would take the necessary steps to ensure protection of the information that they might intercept in carrying out their tests. Members, again, for section 6.1, this is a comment from JBA's initial comment regarding the introduction of the term recklessness in the context of unauthorized interception. I would have reminded the members earlier that the JBA at the sitting in June in 2021 would have withdrawn their initial recommendations in this regard, but notwithstanding, just quickly to point out that the Cybercrimes Convention, on which we believe that our law is premised based on the provisions thereof, speak to the issue of unauthorized interception as well, and indicates that that offense, when being criminalized by parties to the convention, should be done where the interception is intentional and without right. We note also that the Commonwealth model law includes the mental element of recklessness in all other offenses, to include the one we previously looked at, unauthorized modification, but it is ad idem with the convention on this particular offense of unauthorized interception, because a similar approach is taken. That is, within the context of the Commonwealth model law, they have required a mental element of intention. And when we having surveyed other pieces of national legislation and statutes, and the countries are listed there that we would have looked at, it revealed we saw no country that has as a mental element recklessness as something that you do with respect to authorized interception, so that the crime is generally committed intentionally. In even some of the countries, for example, St. Vincent and the Grenadines, that would have applied recklessness to other provisions. With respect to this particular one, unauthorized interception, it is intention that is the mental element that is stated, and the only mental element, I'll add. And then, of course, if we look at our Interception of Communications Act of 2002, we'll note that that particular legislation criminalizes the intentional interception of communication in the course of its transmission by means of a telecommunication network. And so with all of what we've seen, both from the what we call the regional level, specific national legislation, and our own Interception of Communication Act, where the mental element required is intention, we would not, again, members, support the recommendation from their initial recommendation, rather, that that recklessness be introduced into this particular offense of unauthorized interception. The penultimate section, before we get to section 8, at section 7, which treats with unauthorized obstruction or operation of a computer. The same issue arises, members, with respect to the JBA's recommendation that recklessness be introduced, and I wouldn't detain the members that are thinking in respect to this, because it remains the same. We note here that the unauthorized modification, unauthorized obstruction, and unauthorized interference are used in various pieces of legislation. They pretty much mean the same thing. And so our thoughts in respect of section 5, which deals with unauthorized interference, unauthorized modification, is the same as it relates to unauthorized obstruction. And the same countries that would have allowed for unauthorized modification would be repeated here as well again. But again, we caution against the introduction of the mental element of recklessness. And we would have stated those reasons before, and I wouldn't detain the members with repeating them. Which then brings us to section 8, which treats with the offense of computer-related fraud and computer-related forgery. And there were several comments from stakeholders on this particular one, and I'll start with MOCA. So MOCA's recommendation, well, MOCA's observation, I suppose, they noted that based on their reading of the legislation, the act seems to be focused on manipulation only, and not bearing in mind that forgers have now fully embraced the technological advances that have been made and are using the computer to create forged documents. They note that in their view, our criminal law is yet to criminalize the use of computer or use of a computer to create forgeries. And therefore, if a person is found with electronic copies of documents in various stages of completion, for example, then they're likely not to be considered. That would not likely be considered a criminal offense. So they have recommended that the committee consider the introduction of an offense or category of offenses which treat with the possession, creation, and reproduction of electronic copies of forged documents. And some, of course, they've given some examples of some of the documents that would be captured by virtue of an amendment such as that. I'll move to just probably treat with MOCA's, because there are several stakeholder comments. I think probably it might be more effective to treat with them one at a time. What we've noticed on our review of the Forgery Act, and I'll just scroll to that particular area, that section 3.1 of the Forgery Act defines forgery as the making of a false document in order that it may be used as genuine. And then, of course, it goes on to say that forgery with intent to defraud or deceive is then punishable as an offense. We note that the forgery of certain documents is considered a felony and attracts custodial sentences of up to 7 years. Well, a term of 7 years up to life imprisonment, actually. And then there are other documents that, if forged, are considered a misdemeanor and attract a penalty of imprisonment for a term not exceeding 2 years. On further review of the legislation, we note that sections 11 through to 13 of the Act makes it an offense for a person to have in his custody or possession without lawful authority or excuse any of the things that are listed here, whether it's a forged bank or currency note, forged die for the making of gold or silver plates, forged stamp, papers intended to resemble special papers used for banknotes, etc., treasury bills and government debentures, etc. So our observation in respect of Mocha's comments, and apologies, I'm scrolling back up to the top, is that the Forgery Act is technology, in our reading, is technology neutral. So it would apply to documents that are either that are electronically created or reproduced. The Act simply says it's an offense to make a document with the intent to pass it off as being genuine. So we think that makes the legislation technology neutral with respect to what is used to create the actual document. We do note, however, that with respect to the matter of possession, which is one of the issues Mocha had, is that the legislation, the Forgery Act, seems to treat with possession only of certain types of documents, forged documents. Those notes, the forged currencies, the stamps, the seal, die, etc., and makes the possession of those things an offense. And so what we are proposing to the committee is that the committee may wish to consider recommending amendments to the Forgery Act to take into consideration the creation of an offense generally relating to the possession of forged documents with intent to defraud or deceive. And so that would capture would treat with the mischief we think that Mocha is trying to bring our attention to, or to the committee's attention to rather, that there are instances, for example, when there are forged professional examinations, forged degrees, and so on. And so we put that to the committee for its consideration. With respect to the Financial Services Commission, they recommended that the offense under Section 8, computer-related fraud or computer-related forgery, that the offense should be widened to include sending, receiving, or sharing of data obtained from a computer or other electronic device unlawfully with the intent or reckless of the intent to cause harm, damage, or loss to the aggrieved party and or to procure an advantage to him or herself. They argue that the expansion of the definition would allow for the offense to better contemplate financial crimes and money laundering crimes, which do not only include unlawfully obtaining data, but also sharing that data. We want to point out here, committee members, that in our contemplation of the recommendation from the FSC, it appears to us that they are recommending a new offense related to sending, receiving, or sharing any type of information or data. And we don't think, therefore, that it could be considered an expansion of the offense under Section 8. We want to point out to the committee that Mocha also proposed a similar offense of unlawful divulging of information, and we will contemplate both things together in the matrix that we're also preparing in respect of the general recommendations that have come in from stakeholders. So we'll consider this particular matter with you then.
I agree. I agree with that, because this is not only using the modification to your own pecuniary advantage, but you would have transmitted the information so that others can benefit illegally. And so I support the idea of not only it being a new provision, but I think it's a very important provision where they would have deliberately passed on the data or the information that they would have received. And so those now whose data would have been exposed, it would be placed at greater disadvantage because you don't know what the others will utilize it to do. So I support this provision to be included.
And member, so we'll treat with, we didn't, as we said, member, we didn't think that this was something that should be considered for inclusion at this point in time in the legislation, or certainly not under Section 8, because it struck us as to be a new offense.
Right, so what you would be suggesting to us, therefore, is that it be placed elsewhere within the legislation as a new provision.
That would be the contemplation.
Okay.
And we'll treat with all of the subsequent, the other matrix that we'll provide to the committee will treat with all the general comments or general recommendations in respect of new offenses.
Okay.
So that will be a separate submission to the committee members. But this particular one matrix members treats only with the amendments that are proposed to the existing sections.
By the various stakeholders.
Right.
Yeah.
So we move now, since we're taking this in right size. So we'll move to UI's recommendation, having dealt with FSC. And UI has two recommendations here. They note that the act is not clear that there is any responsibility attributed to a resource owner to protect it, and such attribution should be included. And then they further go on to recommend that there be included in the legislation a definition of the word protected that would be applicable throughout the legislation. So with respect to UI's recommendations, we note, let's scroll back up, right? We note that that the legislation does not impose an obligation on resource owners to protect their system. The intention of this particular legislation, as we see it and read it, is that it seeks to delineate the actions that are considered criminal in the area of cybercrime. And of course, the procedural powers pertinent to the investigation and prosecution of such criminal activities. And so it does not get into or treat with the broader area of cybersecurity. So because this legislation is strictly a criminal legislation, or dealing with criminal actions or activities, the imposition of an obligation on resource owners to protect their network, we believe it would not be appropriately included in a legislation like this. If the government is minded, and certainly if the committee can recommend, if it chooses, that there may very well be another legislation that will treat with cybersecurity broadly, and would delineate matters such as the responsibilities that resource owners have to protect their network and impose an obligation on them, then that would be something that could be considered separately, but we don't think that it would be appropriate for this piece of legislation, which is treating with criminal activities. With respect to their second point, that is the introduction of a definition for protected. We wanted to we point the committee to the fact that the term protected is used in the legislation. It's used at section 11, which treats with offenses relating to protected computers. And it defines in section 11 a protected computer as one that is a computer which at the time of the commission of the offense, the offender knows or ought reasonably to know is necessary for or used directly in connection with certain things. And those things include communications, infrastructure, banking, financial services, public utilities. The list includes public transportation and so on. And so to introduce the word protected in the section as proposed by UE would actually restrict the applicability of the section to access to computers that are used for or in connection with the purposes that I've mentioned before. And as the policy intent is that the section have general applicability, that is not that it applies not only to protected computers within the definition of protected in the legislation. We couldn't support the UE's recommendation because we would see that as actually limiting and restricting the applicability of the legislation. Again, we believe that UE is seeking through their recommendation to have to create an environment in which network resource owners, those who operate or have their computer systems and network, that an obligation is placed on them to protect it by virtue of and safeguard it. As we said before, members, while we would support that and and have no objection generally to it, we are mindful that this piece of legislation might not be the legislation to do it because of the scheme of the legislation itself. JBA has 3 recommendations. One of them, the committee members would be familiar with already because we've been discussing it during the course of this meeting and certainly the last meeting. That's the issue with respect to recklessness. The other recommendation they have is that they note rather that financial institutions may experience loss and not just individual persons. They sought clarity as to whether the legislation would apply to companies and not only individuals, bearing in mind that companies can also be victims of cybercrime. And so with that, they recommend that it be made clear in the legislation that victims of cybercrimes may not only be individuals, but also companies. Their third recommendation is that after proving, and this is where here additionally, after proving that a person acted fraudulently, it seems unnecessary to them to also require proof that the person acted with intent to procure an advantage for himself or another person. They therefore recommend that the words "with intent to procure an advantage" be removed or deleted from the section, or alternatively, that a new subsection be added, which creates a presumption of proof that the person acted with intent in predefined circumstances. Members, we have, with respect to their first recommendation regarding recklessness, I won't repeat that. Our review shows that with respect to forgery, and fraud, national legislation generally apply the mental element of intention. And we certainly found no law or identified no law that introduced the mental element of recklessness. We also note that the Cybercrime Convention, which treats with both cyber computer-related fraud and forgery, recommends to members or parties to the convention that when creating that offense, that the mens rea or mental element be intentionality. With respect to whether or not the companies can be considered victims, we note that, I'm scrolling down, that and the AGC, of course, would have advised that and directed us to the Interpretation Act, which defines words that are generally used for application in legislation. And that legislation defines a person as including any cooperation, either aggregate or sole, and any club, society, association, or other body of one or more persons. And so with respect to the need to make it clear in the legislation that victims of cybercrimes include companies, we don't believe that that is necessary, because we believe that the legislation, when interpreted, the use of the word person when interpreted, will be interpreted to mean the natural person and the legal person. I will pause here, Chair, just to ask the Legal Reform Department to treat with the third recommendation from the Jamaica Bankers Association in respect of the removal of the term intent to procure an advantage.
Sorry, that's the one that they are proposing to insert the alternative new subsection that
Yes.
these are the presumption of proof. Yes, I really want to hear an interpretation of that.
So I will,
predefined circumstances.
so I'll pause here, Chair and members, and I'll hand over to LRD.
Good afternoon. In our research, looking on that section, we did not come across any jurisdictions that use defined intent in that way and use these kind of circumstances. And our research is such that we are of the opinion that it is a critical element of the offense to show that the person acted with the intent to procure some sort of advantage. If it's not for himself, well then an advantage for somebody else. And we don't think that it should be removed. It's a, whilst the exact wording varies from jurisdiction to jurisdiction, it is consistent throughout, and it's also a part of the convention itself from which our legislation is modeled. But that's essentially what we found on that provision, and that's why we do not recommend that the proposal of the Bar Association be followed.
Chairman, members, with that particular intervention from LRD, that would actually bring us to the end of the matters before the committee.
All right, thank you very much, CTD. So in relation to the issue raised by Member Campbell, we need the Minister of Education input in that. How would we go about that? We're going to invite them to make a presentation so they can answer questions as well, since it is suggested by SG that they should really be the ones to address it.
I think here it was agreed that we would have sent beforehand the concerns raised with the context so that they can appreciate what we are saying, and so they would be in a better position to respond.
Absolutely, sure. I'm just asking whether or not we want them actually to come to and present at the next meeting so that we can have discourse if required, or you want it back in response in writing, because we will write them for sure.
It could be in writing. I don't know if Senator Campbell Rodriguez would want to question them.
See, the issue is that if we write them and they write us back, we basically we have a document to present, but then if there's any further deliberations, then obviously we'll be at a stalemate again, because it would be... Well,
it wouldn't harm if they come back, sir.
That's the point I'm making. We could just deal with them and get them and then move on to the completion of the matrix.
Right.
All right, so we'll do that. The next meeting is being proposed for next week, Wednesday, the 23rd at 2 p.m. So we'd have to send off that and give them enough time. We'd have to send that letter off immediately between end of the day and tomorrow morning, to give them enough time to prepare to come for next week, Wednesday at 2 p.m.
This is a proposal to date, or was it a agreed date?
I think the only date that's being proposed is next week, Wednesday. I think that is because the dates in March are going to be very difficult based on the Firearms Act. Brandon, can you share something on that with us in terms of timelines? Mr. Nash, you're muted.
Yes, so from what I'm seeing here, the next day definitely will be for the 23rd. In terms of for March, it would be booked for the most part. The Mondays, from what I'm seeing here, will be available. But let's see, first week, second week, the budget debate will be on the 8th and going forward. So the next available time for Wednesday, I'm seeing where there's an opening on 9, but outside of that, it's mostly booked.
Is next week, Wednesday, the 23rd, amenable to the members? 2 p.m.?
Chair, since we lost for dates, we might as well take that one and the next one to come available.
Yeah. The other date, you said, Mr. Nash, is when? March when?
Maybe for, let me just double check again. I'm not too sure if it would be okay for Mondays. On Mondays, definitely would be available.
No, Monday's cabinet. That's all fine.
All right. So then the next possible date that may be available is for the 9th, and that will be in the afternoon. But I would have to double check to see if there's anything.
Can you double check and get that information out to us so we can get that?
Yes, I will.
So we'll go with it to 23rd
at 2
p.m. next week, Wednesday at 2 p.m. I'm not sure CTD if that way you will be in a position to have the balance of the matrix ready for that, because that would be less than a week from now.
Yes. Chairman, we'll aim to get it out certainly by Monday, the latest.
All right, great. All right, so we'll deal with the Ministry of Education and then continue with the matrix for next week, Wednesday, 23rd at 2 p.m. Did you get clarification from me, Mr. Nash, on the confirmation of the minutes held on July 14th, whether that's a mistake?
Yes, it wasn't confirmed. It is that the document was sent, but it wasn't confirmed within the meeting.
Okay, all right. So
Chairman,
bearing that in mind, are we in a position to confirm those minutes now, members, based on the fact that they were circulated? Or you want to put it until next week, Wednesday?
can we take the time to review them and put it until next week?
Sure. So it was inadvertently not confirmed. So yeah, so we'll be in a position to do both next week, Wednesday. Today's
Chairman, are you suggesting that we log the 9th of March as tentative?
Yes.
Until further advice?
Yes, for 2 p.m., right, Mr. Nash?
Yes.
Yeah, 9th of March, 2 p.m. tentative. I will confirm it as soon as possible. All right, members, we are 15 minutes away from our 2-hour time period. So we have gotten through quite a bit today, and we look forward to meeting on the 23rd at 2 p.m. when we'll take the Ministry of Education and take that matter raised by Senator Rodriguez Campbell, and then go straight back into the matrix starting from section 9. All right, until then, keep safe. Everybody have a good afternoon.
Thank you. Have a good afternoon.
All right, Chair. And everyone, take care.